It's quite amazing to have you join us on the fresh edition of Law and You as we have a beautiful outing on a new episode. Last week we treated succession in estate planning, and we're going to be taking off from where we left off last week. A lot of respondents buzzed our line, and we did say that you should please pout your responses on the WhatsApp number right on the screen and not to call. And whatever complaints you have, we pan out into a fresh edition in subsequent times, and it's expected that you do that. So we'll also be having the number riding on the screen today as we take off from where we left off last week, which is still on succession in estate planning part 2. My name is Philip Omo Gyupon. I have the barrister with me, Akigbe Oseo. Thanks for joining me.
Thank you, Mr. Philip.
All right, let's look at the aspect where, you made mention last week about a qualified lawyer. And I believe viewers will also be asking or be interested in what kind of specialized lawyer, can handle the issue of drafting a will, looking at the very, very importance of, interacting with a lawyer that knows his onions, in that regard. So is there a specialized lawyer for that field?
A lawyer is qualified when he has his first degree in law, that is his LLB, and then he's been called to the Nigerian bar, so he has his BL. As long as he has those qualifications, yes, he's qualified to draft a will, although upon getting qualified to practice as a lawyer in Nigeria, you could go a step further to add some further qualifications. But the basic required of a lawyer that entitles him to draft a will is that he's been called to the Nigerian bar. He's qualified to practice as a lawyer in Nigeria. So that's the basic qualification.
Okay, we'll look at the will, which is a document, a legal document, that has to do with the testator, trying to make a wish on or trying to interact with his decision, with the decision on who should take after or take over his estate when he's gone. What can we say categorically are the risks associated with drafting a will outside some having some spiritual reasons to it, that it's like announcing pronouncing one's death sentence? What are the social risks associated with it?
Okay, people, like you said, assume that when you draft a will, it means that you are creating a death wish. That is not the case at all. But you see, death is inevitable. We only pray for long life, right? But let's have the flip side of it. If a will is not drafted, or if there is no estate plan, imagine the issues. So when you consider the likely challenges that will occur if there is no estate plan in place versus if there is an estate plan in place. So you just need to weigh the options, and then when it becomes obvious that there are certain families where it is obvious that once the testator passes on, there will be issues. If he can already tell that those issues are imminent, then it is wise for him to draft a will. So the point is, drafting a will does not mean that the testator will pass on the next day. Not at all. Okay. Not at all. Okay. It's just it's a myth, but it has no basis even in science or in logical reasoning. Okay. You draft a will because the person is trying to create a plan. So it's part of his succession, not to wish for death for himself or any such thing.
Okay. In the last episode, you also made mention of another way of having a will, not just only in writing, but it can also be oral.
Yes.
Do you encourage viewers in that direction, or what do you see as a demerit in having that as against what should be documented?
Well, there is a type of will called it's called non-cupative wills. It's called oral wills. So it depends on the circumstance under which the person is about to pass on. So such wills are made in anticipation of death. So the man, it could also be called a dying declaration, but that basically is more under criminal law. So the man is anticipating that he's going to die soon, right? And then he makes certain declaratory statements. Those declaratory statements in present day, if they are recorded, so the man there is an imminent fear or danger of death, and the man wants to make certain declaratory statements, it's advisable that it is recorded. So maybe he's very frail, and he's maybe old, 100 and something years,
okay.
And then he starts talking. Those statements he made, or he's making, or he will make, is advisable that it's recorded in whatever device. And once those statements are recorded, they qualify as an oral will, which should be respected when he passes on.
Okay, let's look at the aspect of the financial implications, because they say that, well, getting a lawyer may not be cheap. Going through probate cases or issues, where the court will have to look at the document, flip through and make sure that the will, what the testator wants in terms of what will be passing to the offspring or the heir, are followed through. This is not cheap, or is it? And what's the process getting a lawyer in that regard?
Every lawyer will tell you, so every relationship between a client and the lawyer is contractual. There's no fixed rate. So if you walk into a lawyer's office, it is what he charges you pay. So it's not as though what Mr. A is going to ask you to pay is what Mr. B is going to ask you to pay. But aside that, when you consider what it will cost, when there is
no will,
you would rather pay something to save that situation than to allow it degenerate into a situation whereby the deceased children are fighting over property where such a situation could have been avoided. We've seen very eminent persons in society today. When they passed on, the battle arose from the High Court to the Supreme Court and back. Because of the absence of a will, or the presence of a will that was poorly drafted.
Poorly drafted.
Or certain issues that were not anticipated. They've gone to the Supreme Court and they've come back. Now, in that situation, you will be paying lawyers more, because the administrators or the executors will not be funding those cases from their pockets. They will be funding those cases from the estate. So the issue now is, why would you rather wait for an ugly situation to occur where monies that should have gone to beneficiaries will now be used to finance litigation in court? So is it not better for you to settle down and determine how an estate will be, distributed when the inevitable occurs?
Like they say, a stitch in time saves nine.
A stitch in time, just one small stitch could have saved nine. Like I said the last time, we spend most of our time trying to get the assets. If we deploy that quantum of resources
and attention
to determine what will happen when the inevitable occurs, it saves the day. I will give you an example. I know of someone who was a worker somewhere, names withheld, and when he had his last child, as simple as updating his records, he did not. And so that child needed to gain admission into the university. When they checked the record, at that time, you had this staff list and non-staff list and all of that. And so they told him that they told the child that he could go into the university to study a course because his father was once a pioneer staff of the institution. But when they checked the father's records, the father did not update his record to include that last child as his child. As simple as it was, that child would have lost his admission or the opportunity to attend that institution, but for his birth certificate, which carried his father's name and his mother's name. And so they opened a temporary file. The point I'm trying to make is this. We major on the minors, as it were. Nobody wants to talk about death, or nobody wants to talk about creating a will or creating an estate plan because of the fear of dying. But we don't also talk about the ripple effect of not creating a plan.
And actually, it's not even a death pronouncement.
It's not a death pronouncement. It's not a death pronouncement, because those who fail to plan inevitably plan to fail. So at some point, you need to sit down and ask yourself questions. What would happen when the inevitable occurs?
Okay.
All these many assets I have, what will happen? Because you see, the assets are many now and they look beautiful because they are being managed.
Yes, of course.
But you see, when it occurs, you will be amazed that those assets will degenerate into what we call dead capital. That is why when you go around Benin City, you see slogans, writings, inscriptions on properties. This house is not for sale.
We have it everywhere.
This house is not for sale is a reflection of the fact that there is dispute over that property.
Yes, of course.
Now, when you go to more saner climes, more better economies, you have this house is for sale. Because people are eager to sell their properties. There are no issues surrounding the property, so they want to sell. But when you come to these clients,
it's a different
ball game. Now, that inscription on the property devalues the property.
Oh, yes, of course.
Because nobody will want to come forward to buy litigation.
Yes, of course.
So, these are the things we are talking about. If a proper estate plan is put in place, there will be no reason for a certain wife somewhere with a son somewhere coming forward to start fighting over the property.
Okay.
And then another one who has an interest will see it, will consider it conducive to put the inscription on the property to stop the other from getting it. So,
okay. Thank you for that very exhaustive explanation. Now, I think we should dot the I's and cross the T's on the remarks you made earlier. And I still take your mind back to where you said qualified lawyer. I'm thinking of, I think I'm developing cold feet as well as I believe my viewers will be, because, for you to take your money to a lawyer, you want to get value for your money. And who is a qualified lawyer will still be, ringing on your mind, so that you don't make a mistake. Because you said just now that if a will is poorly drafted, now for a will to be drafted, commonsensically, it's expected that a lawyer, is involved. So how do you guide, or how do you prevent such performances, not to degenerate to the point where a will be poorly drafted? Okay, so every lawyer who has been called to the Nigerian bar is qualified. Well, every lawyer. But before you engage that lawyer, you need to look at his resume. Oh, of course.
You need to look at his resume. You need to know, is he an expert in this field?
His experience, the history of performances.
His experience. So, but sitting down here, I will not tell you that a lawyer who has been called to bar is not qualified. He is very eminently qualified. Okay. But does he have the expertise in that area? Those are the things you will have to gauge in determining who to engage. So the field of law has many branches. Criminal law, criminal litigation, civil litigation and all of that, election petition and all of that. So but you need to know the resume of that lawyer before you engage him. You do not just go to a hospital and then ask
because there are pediatricians, there are surgeons
to carry out
different
the function of a dentist. So you need to get someone who has expertise in that area, because you see, you'll be amazed, and I'm restraining myself from stating some of those cases and the eminence of the personalities involved. Some were even very senior lawyers, senior advocates. And upon their demise, there were issues relating to their estate. Even senior advocates. So you'll be amazed that even some lawyers don't even have an estate plan. So, but the point is, so whether a lawyer or non-lawyer or whoever, it's important that the moment you start having assets, and the last time I tried to explain that assets do not mean that you own the whole world.
The whole world, yeah.
Whatever assets you have, it's important that you create an estate plan to avoid unnecessary issues.
Which you can also develop as time goes on.
Yes.
Yeah, it's amenable to changes.
Yes.
Okay.
For example, even working in any establishment, and then by the Pension Reforms Act, deductions are made, for pension and all of that. The question is, who takes that money when the inevitable occurs? You will be amazed when you check the records that it's not even been updated.
Okay.
And then a name is put there as next of kin. Who is the beneficiary?
Who is the beneficiary?
Remember, a next of kin is someone you have to call for when there is an emergency. A next of kin doesn't necessarily mean that he's the person entitled
the heir
to the
property.
Yes. So you need to. These are issues that we need to explain to the larger society, that creating an estate plan is necessary.
Yes.
Is necessary.
Just like we've gotten to the juncture where we look at issues concerning in the will, where you now say, okay, the testator will have to, get a guardian, for the minor, just in case of any eventuality. That in case for children, for instance, if it happens that the inevitable occurred while the children are still very young, there's need for a guardian to see through, the property until they are old enough, so things like that. How do you guide, a testator in terms of ensuring that the right guardian is put into cognizance? Because we've had issues where, as a result of the demise, guardians may now become beneficiaries. So how do you guard against that?
That is why you have a minimum of 2 executors. A minimum of 2 executors. Okay. They are duty bound to ensure that the wishes of the testator or the testatrix sees the light of day.
Okay.
He cannot now, on his own, appropriate the property for himself.
Okay.
He will be liable to some explanation by the courts. He is bound to ensure that those wishes are carried. And
the lawyer again is also in the picture.
The lawyer assists in bringing. It's like you are cooking a pot of soup. What he does is to bring all the ingredients together to ensure that you have a good meal. Right? So he ensures that the executors, you have the executors, you have the witnesses, then he ensures that the beneficiaries are clearly stated,
okay,
the assets are clearly stated, and the intention is clearly stated. Once that is done, we'll have a good document.
Okay, earlier we were talking about there is a need for beneficiaries to know about the will, until the inevitable occurs. And now, for minors, for instance, at the advent of death or at that occurrence, do they need to know about the will?
When you say minor, well, under our laws, you are talking of someone below the age of 18. If he's 16, 17, 15, the knowledge, I'll put it this way. In the past, when a man writes a will, there are certain persons he could disclose that information to. The reason why is he is trying to, so that they are not left in the dark when the inevitable occurs.
Yeah.
Now, that was the intention, so that when he dies, they said when they get to the point of distributing his assets,
there won't be vacuum.
There will not be vacuum. Everybody knows that he wrote a will. And remember, there were witnesses, there are executors, and then the family members are aware. But the problem with that is that from the cases I've done, I've seen that certain elements in the family will go ahead to create a counter document.
Okay.
So when the inevitable occurs and then they go to the probate registry and then the will is read, certain elements in the family will then bring another document to say, oh, this was the document that he created in his lifetime. So you now
falsified.
have all manner of documents everywhere.
Circulating.
In fact, I did a case where in one of the so-called wills, as it were, they inserted some clauses to say that some of the children of the beneficiary were illegitimate.
Wow.
Just to disinherit them.
Yeah.
And it took the grace of God for the testator to get to know what had been done and had to write another will, prepare another will to revoke all others.
Oh, beautiful.
So even in his lifetime, there was already
attempts.
Headache. So imagine, as we speak, there are issues. So what I would advise is that once a will has been written, of course, a lawyer prepared the document.
Yes, of course.
Lodge the will with the probate registry.
Yes, of course.
Once it is lodged, and then ensure that the executors are men of character, men of integrity, so that the wishes are kept, are secured when the inevitable happens. I think that will be fine.
Okay, in case you're just watching this Law and You, and we've been interacting with a custodian of the law, Akigbe Oseogo, and we are looking at succession in estate planning, part 2. I did say that you should pouch your responses or reactions on the WhatsApp number that also doubles as the text line, and whatever you pan out will be used for subsequent editions. I am Philip Omogupo. Now let's quickly go to some reports that I came across about inheritance tax. Now I was a little bit taken aback. What is inheritance tax? And does poor drafting of the will, exacerbate such issue?
No, not at all. So inheritance tax is one of the drawbacks in a will. For if you choose the option of drafting a will, then inheritance tax is one of the drawbacks. So I'll explain. The man has written a will, appointed 2 executors, right? Now, when the inevitable occurs, the 2 executors will apply for a document from probate, letters of administration. That document is what empowers them to then transfer the property to the individual beneficiaries. That transfer is through another document called a deed of assent. Now, when the property is transferred, so what empowers the executors to carry out that transfer is the letters of administration, right? And then they now create another document, a deed of assent, to transfer to the beneficiaries. That process of transferring the asset, the process of even obtaining letters of administration, you will pay inheritance tax. The government will value that property and take 10% of the value of the property alongside other sundry statutory fees.
So that's legal.
That's legal
and normal.
It's normal. You pay inheritance tax. When the property now moves from the estate to the beneficiary, for the beneficiary to have to perfect the title, there are certain fees he too will pay. So I'll give you an example. The man has a parcel of land. The executors have obtained letters of administration over that land. The government will ask them to pay 10% of the value of that land. Now, when eventually it is transferred to the beneficiary, remember, the name on the title document is still the name of the father of that child. That child will then go to Edo GIS to apply for a certificate of occupancy or a document covering that title that bears his name. That's another process of obtaining consent. So one of the drawbacks of writing a will is the process of paying inheritance tax, the process of perfecting those titles.
Wow.
So it's a lot of money.
Okay.
So that is why we often say that writing a will is not, you look at the situation whether it is appropriate for it. It's not a one size fits all.
Yeah.
So you could create a hybrid system, not necessarily the traditional mode. You have to look at the value of that property and ask yourself a question. Should I write a will and subject my children to the payment of estate fees, inheritance tax, and all of that? Should I not just transfer the property to the child I want to have it in my lifetime?
All right.
And let him have it and know that it's gone.
All right, thank you so much, Oseogo Akigbe. I want to thank you once again for your exhaustive explanation and for giving us the opportunity to tap into this knowledge where the viewers are also benefiting. Next week, we're going to be looking at trust and what trust is. How different is it from a will? Are they the same thing, or what could be their differences, and what advantages could trust have in estate planning? We do this. Don't forget your responses, your reactions are patched on the number writing on the screen, which doubles also as our WhatsApp and our text line for us to use that to treat the next edition. See you on the next one. Goodbye.